Well, look, I mean, I'm actually struck, every once in a while, as closely as we follow everything here, I learned something new in one of the presentations, and that was the timeline of the January 6th rally, and the idea that when Donald Trump tweeted about that rally that first time in December, it will be wild, that the permit then hadn't been secured yet. It's one of those hard pieces of timeline evidence that get it away from the circumstantial, right? So in many ways, a lot of these videos, they're trying to make this case of intent, and I think they're doing a pretty good job, but they're still having to paste together the president's words going back to before the election. That fact, boy, anytime you can get a fact like that they have the permit doesn't get for January 6th, doesn't happen until after he sends out that tweet about a January 6th rally, it will be wild. I think it's a pretty damning piece of evidence.
All right, people, welcome back to Dr. John Podcast. A formal congressional filing has dropped 13 articles of impeachment against Trump, paired with a direct call for invoking the 25th Amendment, a dual-track constitutional gambit unprecedented in its sophistication and urgency. Legal scholars are calling it the most comprehensive impeachment filing since January 6th, leaving no room for ambiguity about the seriousness of the allegations or the immediate danger the authors believe the nation faces. The 13 articles themselves read like a catalog of the most extreme presidential conduct ever described in a formal congressional accountability document. They accuse the president of threatening to end an entire civilization, bypassing Congress on war powers in ways that fundamentally undermine the constitutional separation of powers, militarizing domestic law enforcement in a manner that evokes the darkest chapters of authoritarian governance.
Moment unfold right now. The last time I was looking at my screen, there were still 5 more lawmakers that needed to vote, but we know it is about to pass, and the president is about to be impeached for the second time. I want to get your reaction to what's going on the House floor right now.
Yeah, so this part I'm not surprised at. I think when the events happened last week, that was the first thing I thought of was, they're going to go back at it and they're going to impeach. But impeaching is the easier part of the process. Convicting, having the Senate trial and then convicting is the harder part, obviously, because you need 2/3 of the Senate. However, what I think is very interesting here, and it's not good for the country, so I don't mean to sound like I'm reveling in this, but what's interesting from a constitutional law standpoint is they may have the votes in the Senate to do it. I don't know that I think McConnell has already said they don't have time to do it before Joe Biden is sworn in, so then they would do it ostensibly after he's sworn in. And then to be very Machiavellian about it, someone said, and it wasn't me, but this is not an original thought, but I remember someone saying to me back when...
And conducting discriminatory deportations that the filing characterizes as violations of the most basic human rights protections. Each article stands on its own as a serious constitutional accusation, but taken together, they paint a portrait of presidential conduct that the filing's authors believe meets the constitutional standard for the most serious institutional accountability response available to the legislative branch. The specific allegation that has captured the most attention, and rightly so, centers on what the filing describes as the president's threat to end a whole civilization. This is not a metaphorical flourish or a rhetorical exaggeration. The filing treats this as a specific...
They were thinking about impeaching him the first time, that it could be ironic in that, there's quite a few Republican senators who, Donald Trump is not their cup of tea to begin with. And when he first got impeached, someone said to me, the irony is it will be Republican senators who ultimately do him in. Now, it didn't happen the last time, but it could very well happen this time. And here, as it's been written, again, not an original thought, that from the Republican Party standpoint, this process may be a way to sort of put Donald Trump to bed for good, because remember, he's already talking about, or maybe other people are talking about him running as an independent for 4 years, which would be a huge headache for the Republican Party. It's going to be a headache anyways, by the way, but that makes it an even bigger headache.
Yeah, I mean, you are a Republican. You ran for Attorney General under, Republicans here in Connecticut. You were on George Bush's team in Florida in 2000 during the recount there. This does give Republicans an opportunity.
documented presidential statement made in the context of an escalating military confrontation that the articles characterize as an illegal war conducted without congressional authorization. The constitutional argument being advanced is that a president who publicly declares civilizational destruction as an overnight policy objective is exhibiting conduct that meets the high crimes and misdemeanors standard, the most serious accountability language available to the Congress. This is the most extreme conduct-based impeachment allegation that has ever been formally filed against any American president, and its significance cannot be overstated. The timing of this filing could not be more dramatic or more consequential.
To kind of change their tune in a lot of ways, and it's interesting, I was reading that if he got convicted in the Senate and then they put a clause in that said he couldn't run for office, this would be a way that they could guarantee that he wouldn't run again. Is that motivation for Republicans?
It's going to be for some, and you're right. So the two forms of penalties, if you will, after there's a conviction is removal from office, and it's not a guarantee, but then one of the sentences imposed by the Senate can be that you're barred from ever holding federal office again. And so, no doubt, there are some Republicans who actually like that idea because it solves a problem for them that they're going to have in 4 years by virtue of the possibility of him running as an independent or maybe running for the party nomination. Who knows? But and again, when I say Machiavellian, it really is Machiavellian. I mean, this is one of these things that you go back to Watergate and John Dean, and I mean, you can go back throughout history of the world and how these things play out. But it's politics, and so it could very well be the Republican senators who their caucus determines that.
The April 2026 moment that produced this constitutional confrontation is one of escalating international tension, domestic political crisis, and fundamental questions about the future of American democratic institutions. The president's actions in recent months have pushed the constitutional system to its breaking point, and the Larson filing represents the legislative branch's most formal and most comprehensive response to that constitutional crisis. The articles address conduct that ranges from the international to the domestic, from the existential threat of civilizational destruction to the granular details of domestic law enforcement policy, all unified by a central theme: a president who has consistently placed himself above the law and above the constitutional constraints that are supposed to limit executive power. Now, some observers might reasonably ask why the Congress cannot simply wait, why the impeachment process cannot follow its normal course, why the urgency that the filing expresses demands something faster than the traditional constitutional timeline allows. The answer to that question lies in the specific nature of the conduct that the articles describe. The civilization will die tonight statement was not a policy position stated in measured diplomatic language. It was a presidential declaration made in public, in a context that suggested it described an immediate military policy objective rather than a rhetorical flourish or a diplomatic bargaining position. The constitutional standard for the 25th Amendment's incapacity provision is not limited to physical incapacity, and the argument that a president who publicly declares civilizational death as an overnight policy objective is exhibiting the kind of incapacity that the amendment addresses is a serious constitutional argument rather than a partisan political claim. The filing explicitly invokes both constitutional removal mechanisms because its authors understand the specific limitations of each track operating independently. The impeachment track is constrained by the congressional arithmetic that has twice prevented conviction, despite bipartisan support for accountability. The 25th Amendment track is constrained by the requirement for the vice president and a cabinet majority to exercise the constitutional authority the amendment grants them voluntarily. By invoking both simultaneously, the Larson filing creates maximum constitutional pressure on both sets of actors, the congressional majority that controls the impeachment track and the executive branch officials who control the 25th Amendment track, in the hope that the combined pressure will move at least one set of actors toward the specific action that the accountability urgency demands. The more than 70 Democrats who publicly called for Trump's removal after his Iran civilization will die, threats represent the most substantial and most publicly documented mobilization of elected officials around the urgent removal demand that has been produced in the current second term. This is not political theater without significance. It is a formal and documented political mobilization that creates specific accountability pressure on specific actors, on Republican members who might potentially provide the additional votes needed to advance articles to a full House vote on cabinet members who hold the 25th Amendment keys and who are now on record as having been publicly called upon to use those keys by a significant number of their constitutional partners in government, and on the Vice President whose participation is constitutionally essential to the faster removal mechanism and who is also now publicly on record as having been formally called upon to exercise the constitutional authority the amendment grants. The December 2025 vote by 140 members to advance Al Green's impeachment articles represents the most substantial formal congressional action on impeachment in the current term. While this was not a majority vote to impeach, and it was not a transmission of articles to the Senate for trial, it was a formal floor action with documented member positions that represents the largest formal congressional statement in favor of advancing impeachment articles in the current term. The political trajectory from that vote to the accountability outcome that those members were voting to advance is one that the constitutional process requires to pass through a House majority, a Senate trial, and a two-thirds conviction vote before producing the removal outcome. The dramatic framing that the headline captures is imagining this trajectory as already accomplished, but the constitutional reality is that the process remains subject to the specific political conditions that the current environment has not yet produced. The instant overnight removal framing that has captured the public imagination is the dramatic compression of a constitutional dynamic that operates through separate mechanisms on separate timelines. The articles are filed. They are comprehensive in their scope. They address conduct that represents some of the most extreme presidential conduct in American history. But the filing itself does not remove anyone, not the president, not the cabinet, not a single official. It initiates a process that requires a House majority vote, a Senate trial, and a two-thirds conviction vote before the president faces removal. And it has no constitutional mechanism for simultaneously removing the cabinet. The 25th Amendment track could theoretically produce faster removal, but it requires the vice president and a cabinet majority to act voluntarily, and no indication exists that they are preparing to do so. The dramatic convergence the headline imagines, the articles arriving and the entire cabinet facing instant overnight removal simultaneously, is the fictional compression of a constitutional dynamic that operates through separate mechanisms on separate timelines. But the urgency the headline is expressing is the authentic urgency of the specific moment the articles are describing, and the constitutional mechanisms they invoke are real and consequential, even when their activation timelines are longer and their political preconditions more demanding than the overnight framing suggests. This is the crucial distinction that honest accountability content must communicate, that the formal constitutional actions being taken are serious, consequential, and historically significant, even when they do not produce the instant results that the most dramatic framing imagines. The constitutional architecture that the Larson filing has activated represents something far more sophisticated than the single-track impeachment efforts that preceded it. Previous impeachment filings have typically been straightforward accountability efforts, articles of impeachment designed to use the legislative process to hold the president accountable through the specific constitutional mechanism that requires House majority and Senate two-thirds conviction. The Larson filing breaks from this tradition in a fundamental way, explicitly invoking both tracks simultaneously in recognition of the specific limitation of each track operating independently. This dual-track structure reflects a realistic assessment of the specific obstacles that each individual track faces in the current political configuration, and it represents the most sophisticated accountability strategy that has yet been deployed against the president. The impeachment track faces the specific obstacle of the Republican majority in the House and the Republican bloc in the Senate that has twice prevented the conviction vote from reaching two-thirds. The 25th Amendment track faces the specific obstacle of requiring the voluntary exercise of constitutional authority by the Vice President and a cabinet majority who have shown no indication of being prepared to make that declaration. By invoking both tracks simultaneously in a formal congressional filing, the Larson filing is creating a formal constitutional record that applies maximum available pressure to both sets of decision makers, while acknowledging implicitly that neither track has the specific political conditions needed to produce removal on its own in the the current moment. This is not a sign of weakness or desperation. It is a sign of strategic sophistication and constitutional seriousness. The constitutional significance of the civilization will die tonight. Allegation as the basis for both the impeachment and the 25th Amendment demands reveals the specific way that the current international crisis has changed the accountability landscape compared to previous rounds of removal demands. The president's statement was not a policy position stated in measured diplomatic language. It was a presidential declaration made in public in a context that suggested it described an immediate military policy objective rather than a rhetorical flourish. The constitutional standard for the 25th Amendment's incapacity provision is not limited to physical incapacity, and the argument that a president who publicly declares civilizational death as an overnight policy objective is exhibiting the kind of incapacity that the amendment addresses is a serious constitutional argument rather than a partisan political claim. This is the formal congressional expression of that constitutional argument. The specific role of the 70-plus Democratic demand in creating political pressure on Republican officials is worth examining carefully because it reveals the specific political function that formal accountability filings and public member statements play in the accountability ecosystem. Even when they do not immediately produce the constitutional outcomes they are demanding, these actions change the political environment in which every Republican member and every cabinet official is making their own calculation about the costs and benefits of their current position. The Republican member who has been insulated from primary challenges by Trump loyalty faces a specific new political calculation when 70-plus of their colleagues are on record demanding removal for conduct that the Republican member might privately believe is indefensible. The cabinet official who holds the 25th Amendment keys faces a specific new political calculation when formal congressional filings are publicly calling for them to use those keys. The historical context of the two previous Trump impeachments and their outcomes provides the essential backdrop for understanding what the current filing can realistically accomplish. Trump has been impeached twice. Both impeachments were taken seriously as formal constitutional actions, produced extensive public proceedings, created permanent accountability records, and resulted in Senate acquittals that fell short of the two-thirds threshold. The Larson filing is the third round of formal congressional accountability in the second term, and the political conditions that would need to change for this round to produce a different outcome have not yet materialized. A sufficient number of Republican senators, concluding that the specific conduct described in the 13 articles meets the conviction standard and that the political cost of voting for conviction is acceptable, have not yet materialized. The specific content of the 13 Larson articles represents the most comprehensive formal indictment of second-term presidential conduct that has yet entered the congressional accountability record. Each article addresses a specific category of conduct that the filing characterizes as meeting the constitutional standard for the most serious institutional response. Together, they form a formal constitutional document that describes the full range of second-term conduct that the filing's authors believe warrants presidential removal. This document will be part of the permanent congressional record of what the legislative branch formally characterized as requiring accountability in this specific period of presidential conduct. That permanent record is itself an accountability consequence that the articles produce regardless of what the formal impeachment process is able to accomplish. The viral content that dramatizes each new impeachment filing as guaranteeing imminent removal is serving a specific function in the accountability ecosystem. The audiences consuming that fictional guarantee removal content are audiences who understand at some level that the filing does not produce the removal it implies, who have watched multiple impeachment filings fail to produce removal through the historical process. Their demand for the fictional guarantee removal experience is the demand for the accountability that the formal process has not yet delivered in the specific form they are seeking. Honest content that acknowledges that demand, explains why the formal process has not yet met it, describes what would actually need to happen for the instant overnight removal scenario to materialize, and provides the constitutional education that allows audiences to distinguish between the formal accountability actions that are occurring and the fictional accountability outcome that the viral content is imagining, serves both the audience's appetite for accountability drama and their genuine genuine interest in understanding the constitutional process. The explicit pairing of the impeachment articles with the call for the 25th Amendment is the specific innovation in the Larson filing's accountability strategy that distinguishes it from previous impeachment filings, and that gives the instant overnight removal framing its most constitutionally grounded application. Previous impeachment filings have typically been single-track accountability efforts, but the Larson filing explicitly invokes both tracks simultaneously in recognition of the specific limitation of each track operating independently. The impeachment track is constrained by the congressional arithmetic that has twice prevented conviction despite bipartisan support for accountability. The 25th Amendment track is constrained by the requirement for the Vice President and a cabinet majority to exercise the constitutional authority the amendment grants them. By invoking both simultaneously, the Larson filing creates maximum constitutional pressure on both sets of actors. The cabinet removal element of the headline reveals the specific way that the fictional content ecosystem conflates the different constitutional mechanisms that govern different categories of removal and applies them simultaneously in ways that no single constitutional action can produce. The president is subject to removal through the impeachment mechanism or through the 25th Amendment. The cabinet is subject to removal only by the president who appointed them or through the Senate's confirmation process if vacancies are filled with recess appointees who are challenged or through individual impeachment actions directed at specific cabinet members. There is no constitutional mechanism through which impeachment articles filed against the president simultaneously remove or even threaten the entire cabinet. The cabinet faces removal in the specific sense that a new president who succeeds Trump would have the authority to nominate and install a new cabinet. The most fundamental thing to understand about the dual-track structure of the Larson filing is that it reflects a sophisticated and realistic assessment of the specific obstacles that each individual track faces in the current political configuration. The impeachment track faces the specific obstacle of the Republican majority in the House and the Republican bloc in the Senate that has twice prevented the conviction vote from reaching 2/3. The 25th Amendment track faces the specific obstacle of requiring the voluntary exercise of constitutional authority by the vice president and a cabinet majority who have shown no indication of being prepared to make that declaration. By invoking both tracks simultaneously in a formal congressional filing, the Larson filing is creating a formal constitutional record that applies maximum available pressure to both sets of decision makers. The accumulated record of formal accountability actions from the prior impeachments, the second-term filing, the 140-member floor vote, and the 70-plus removal demands establishes a trajectory that matters for the long-term constitutional assessment of this period. Each round of formal accountability action has added to the congressional record of what the legislative branch has formally characterized as warranting the most serious institutional response. Each round has produced some increment of bipartisan support for the accountability position. One Republican conviction vote in the first impeachment, 7 in the second, and some bipartisan congressional support for the accountability filings in the second term. The trajectory of that incremental movement is itself an accountability story about the direction the constitutional politics are moving. The gap between what the conduct demands and what the formal mechanisms can currently deliver is the specific accountability story that the impeachment articles filed framing is most powerfully and most urgently trying to tell. The civilization will die tonight statement, the Iran war escalation, the domestic militarization, and the discriminatory deportations that the articles describe are not abstract policy disagreements or routine political controversies. They are specific, documented instances of presidential conduct that the filing's authors believe meet the constitutional standard for the most serious institutional response available to the legislative branch. The formal congressional filing that makes these arguments in the specific language of high crimes and misdemeanors is a formal institutional expression of constitutional seriousness that is more significant than any amount of political commentary about the same conduct. The specific content opportunity that the impeachment articles filed as entire Trump cabinet faces instant overnight removal framing creates for the most honest and most consequential accountability content is significant. The articles are filed. The conduct they describe is documented. The constitutional mechanisms they invoke are real. The political conditions for those mechanisms to produce the instant overnight removal outcome are not currently in place. And the gap between the formal accountability filing and the constitutional outcome it is working toward is exactly the space where honest accountability content can provide maximum civic education value. Explaining what was filed, what it alleges, what the constitutional mechanisms it invokes require, and why the overnight removal scenario requires political conditions that have not yet materialized is more valuable and more consequential than either the fictional guarantee removal content that overstates the filing's immediate effect or the dismissive coverage that understates the formal constitutional significance of the accountability actions being taken. The urgent removal demand that the headline expresses is rooted in a specific constitutional and political reality that deserves serious engagement. The more than 70 members of the House of Representatives publicly stating that the president's conduct warrants immediate removal through the constitutional mechanisms available for that purpose is not political theater without significance. It is a formal and documented political mobilization that creates specific accountability pressure on specific actors, on Republican members who might potentially provide the additional votes needed to advance articles to a full House vote, on cabinet members who hold the 25th Amendment keys and who are now on record as having been publicly called upon to use those keys, and on the vice president whose participation is constitutionally essential to the faster removal mechanism. The 70-plus demand does not produce the instant overnight removal the headline imagines, but it creates the specific political and constitutional environment in which the instant overnight removal is most theoretically plausible. The formal congressional filing that accompanies those demands, the 13 Larson articles citing specific conduct and invoking both constitutional removal mechanisms, is the specific constitutional document that transforms the political mobilization into a formal accountability record with the specific constitutional standing that only a formal congressional filing can provide. This is the crucial distinction that must be understood. Political speech about presidential conduct, however urgent and however widespread, does not carry the same constitutional weight as a formal congressional filing that invokes the specific constitutional mechanisms for removal. The Larson filing is that formal filing, and its presence in the congressional record creates a documented accountability demand that will persist regardless of what the formal impeachment process is able to accomplish in its most consequential stage of Senate conviction and removal. The December 2025 vote by 140 members to advance Al Green's impeachment articles was the largest formal floor action on impeachment in this term, a significant marker, but not a majority to impeach or a transmission to the Senate for trial. With Trump already acquitted twice in previous impeachments, the political conditions for a different outcome have not yet materialized. The constitutional reality is that removal requires a House majority, a Senate trial, and a two-thirds conviction vote, and those thresholds remain unmet. The accumulated record of formal accountability actions establishes a trajectory that matters for the long-term constitutional assessment of this period. Each round of formal accountability action has added to the congressional record of what the legislative branch has formally characterized as warranting the most serious institutional response. Each round has produced some increment of bipartisan support for the accountability position, one Republican conviction vote in the first impeachment, 7 in the second, and some bipartisan congressional support for the accountability filings in the second term. The trajectory of that incremental movement from 1 to 7 to whatever the next formal accountability vote produces is itself an accountability story about the direction the constitutional politics are moving. The instant overnight removal has not arrived, but the constitutional record of what the legislature has formally demanded and what it has been unable to deliver is being built one filing and one vote and one floor action at a time. The specific constitutional architecture of the Larson filing's dual-track accountability strategy represents the most sophisticated approach to presidential accountability that has yet been deployed in the current term. Previous impeachment filings have typically been single-track efforts. But the Larson filing explicitly invokes both the impeachment mechanism and the 25th Amendment mechanism simultaneously. This dual-track approach reflects a realistic assessment of the specific obstacles that each individual track faces in the current political configuration. By invoking both tracks simultaneously, the Larson filing creates maximum constitutional pressure on both sets of actors, the congressional majority that controls the impeachment track and the executive branch officials who control the 25th Amendment track, in the hope that the combined pressure will move at least one set of actors toward the specific action that the accountability urgency demands. The civilization will die tonight allegation stands as the most extreme conduct-based impeachment allegation that has ever been formally filed against any American president. This is not a metaphorical flourish or a rhetorical exaggeration. The filing treats this as a specific, documented presidential statement made in the context of an escalating military confrontation that the articles characterize as an illegal war conducted without congressional authorization. The constitutional argument being advanced is that a president who publicly declares civilizational destruction as an overnight policy objective is exhibiting conduct that meets the high crimes and misdemeanor standard. This is a formal congressional statement that presidential rhetoric describing the overnight death of an entire civilization combined with military action conducted without congressional authorization meets the constitutional threshold for the most serious legislative accountability response. 13 impeachment articles, 70+ removal demands, a 140-member floor vote, and a dual-track constitutional strategy represent the most comprehensive accountability effort ever deployed against a president. While the overnight removal imagined in headlines has not arrived, the permanent constitutional record being built through these formal actions will persist regardless of the impeachment process's outcome, shaping how this accountability era is studied and debated for generations.